Note number 32 on testing Hoyokumar Gupta's matter. Item number 89. There is direction for personnel of IC program to please with the report.
So what can be taken? The learned judge has want the personal appearance. How can I? What is the requirement of personal appearance?
Madam, because the report was called for through the IC.
Okay. Report is ready.
Report.
So how can I take up the matter?
And only distance with personal appeal, then item number 89.
What is the record? Then না না হয় কি করে? তা হয় নাকি? রেজিস্ট্রি চ্যানেলের অথরিটি কোথায় আছে? There is no authority registry channel. Either you have to move at second half after reaching the file to this court, either to come on Monday.
No, it is requested from Ganga, then Madam 2 p.m.
2 p.m. Today is the last date. কিন্তু এই matter essential আছে. Come on 2 p.m.
Item number 89.
Give me the number.
Well, it may be permitted to mention.
What mentioning? Today is not the date of
no,
mentioning, you
it
know.
is very urgent because Monday, my lord, attachment order is going to be passed. My lord, I'm for.
So what can I do now?
To be mentioned, my lord, Monday, my lord.
No,
Only
today I am not allowing any mentioning.
My lord, it is very urgent.
You know the
my
rule.
lord, attachment order will be passed, my lord.
Let it be attached. What is the issue?
My lord, I am.
No, why not mention on Wednesday? After attachment order, you are moving this court.
No, attachment order has not yet been passed. Monday
Then
it will be passed.
Monday it will pass.
Monday.
Come on Monday.
My lord, it will be very kind of you, my lord. Kindly, my lord.
You know the rule. Today I am not
Yes,
hearing the mentioning anything. No. Come on Monday. Come on Monday.
To be mentioned.
No issue. Only... No issue. No issue. Nothing is issue is there. Let it be attached. Thereafter order will be passed. No issue. Why you not mention it on Wednesday?
Well, the information came to me on Wednesday evening.
Then Wednesday you have to move it.
Evening, my lord. That is why I could not.
Then you have to move on Monday. That is the rule.
Smart, I know, my lord.
Then
even after that, my lord, if my lord kindly permit me.
You are appearing on behalf of whom?
Insurance company, my lord, ICICI Lombard General Insurance Company. Only stay application.
Okay. Monday.
Monday to me.
Monday.
Yes.
My lord, item numbers 1 and 2 may be taken up together. I am appearing for the petitioner, my lord. They're analogous matters. My lord, the interim order earlier granted, my lord, that expires tomorrow. We have filed the application within time. My lord, this is the affidavit of service pertaining to item number 1.
Item number 1, I am appearing for the state.
I am appearing on behalf of Hon'BLE Mitra for ROC, respondent number 2.
Private respondent number 2.
Item number 2, Mr. Ogunpalli.
For?
ROC.
ROC.
May the affidavit of opposition be taken? This is for in regards to item number 2.
Affidavit of opposition. In respect of?
Item number 2.
No, against whom? Cran? Against the Cran?
No, my lord, it is with regard to
affidavit of the main matter.
Main criminal divisional application.
So what is the application?
My lord, the application is for quashing of the proceedings of
No. Extension of interim order.
Extension of interim order, my lord.
Cran number 10.
Cran number 10, lordship.
Affidavit in reply and affidavit of opposition is exchanged between the party. So kindly fix a date for hearing. In the meantime,
the date will be fixed by the
regular bench, my lord.
Yes, by the regular bench, not by me.
in the matter.
Okay, extension of interim order in respect of CRR 1881
Eight.
of 2020 only,
Yes, your lordship.
not in item number 2.
No, item number 2 also, lordship. I have not handed over the act. Yes,
Okay,
lordship. One by
one after another.
Item number 2's affidavit of services with me, your lordship.
Very well. Please take down. Affidavit of service filed on behalf of the petitioner is taken on record. Grant 10 of 2024. Head call. Grant 10 out of heading call. This is an application for extension of interim order dated 29 February 2024. Passed by this court on the earlier occasion. Heard the learned advocate for the petition. Heard the learned advocate for the state as well as the opposite part, private opposite party number 2.
So private
Stroke ROC.
authority, ROC.
ROC. Stop. Considering the submissions, it appears to me that the interim order was extended time to time by this court on the earlier occasion in response to the separate CRAN applications. Stop. The instant criminal revision is ready for hearing. Considering the circumstances of this case, I think it necessary that the CRAN application being CRAN 10 of 2024 is required to be allowed in favor of the petitioner. The interim order, accordingly, the interim order passed by this court on the earlier occasion is hereby further extended till till 19th of April
Lordship,
or until further order, which was
lordship, can it be till the end of April, as my next date before the learned court below is on the 25th?
25th.
Yes, your lordship, of April.
The matter is ready, so matter can be disposed of before that. What the issue?
Lordship, only till the end of April.
Let you start the hearing.
My lord,
Otherwise,
we shall, my lord. But
very well.
can he extend the interim order till the end of April?
Interim order till the 19th. The matter shall appear in the list on 15th of April. 19th or extended till the or until further or whichever is 19th or until further or
My
whichever
lord,
is.
only till the 25th of April, that on when my next date is. My lord, let the matter appear on the
Okay, very well, 25th
lordship.
or until further or whichever is.
Lordship.
Grant 10 of 2024 disposed of.
My lord, this is the affidavit of service pertaining to item number. My lord, on the last occasion, time was granted for filing our opposition. We want to file the opposition today.
Lordship, I am appearing on behalf of the state.
Service has been completed, my lord.
Do you want to file any reply?
Yes, my lord, we have to file the reply. We have received the service of it. My lord will kindly direct that on the next date we shall file the reply.
Okay, please take down. CRAN 12 of 2024. Affidavit of service filed on behalf of the petitioner is taken on record. State is represented. Private opposite party, stroke
My lord,
number 2 ROC also represented. Stop. This is an application for extension of interim order. It appears that on the earlier occasion, the interim order was extended by virtue of certain CRAN applications. Stop. It appears to me that the matter is otherwise ready for hearing. So the interim order passed by this court on the earlier occasion is required to be extended further. Accordingly, the CRAN, accordingly, the application being CRAN 12 of 2024 is disposed of with a direction that the interim order passed by this court on the earlier occasion is further extended till the
25th.
same date.
Yes, lord. 25th of
25th
April.
of April 2024 or until further order whichever is earlier. Stop. The matter shall appear in the list on 15th.
My lord, deeply obliged.
15th of April. Stop. Next para. The next para. The the opposite party number 2, the register of companies, filed affidavit in opposition. Stop. After serving a copy of the same to the petitioner. Stop. The petitioner be at liberty to file the reply against the affidavit in opposition filed on behalf of the opposite party number 2 within the returnable date.
Deeply obliged. Take my mic.
Yes, my lord, this appeal, which was disposed of by your lordship on 25th January 2024. My lord, has come to your lordship at my a little with a twofold prayer. Now, my lord, your lordship kindly see the order passed by your lordship on my lord 25th January 2024. The appeal was disposed of. My lord, this appeal, my lord, the appeal preferred by the insurance company and also along with my appeal court were disposed of. My lord, the award of this 10,44,500 has been reduced to 8,50,000. My lord, it appears from the first page, the lordship kindly see, we are in the CAN 7 of 2023. First page.
Yes.
Now, my lord, on the date of judgment, the say that CAN 7 be disposed of. CAN 7 is a formal matter petition for amendment of names and mother. CAN 7 is in on the date of judgment, mother. CAN 7 was not available. Mother, you lordship kindly see CAN 7. The lordship got it CAN 7.
So why it is appearing for
Yes.
correction?
Corrections and for disposal of my CAN 7. CAN 7.
Then it will be appear under to be mentioned, not for correction. CAN 7 actually
also
CAN
mother,
7 was not on the record. That's why the CAN 7 was not disposed of.
mother, CAN 7 may be disposed
Now
of.
it is on the record.
Yes.
It was
Can-
not reached to the record. That is the reason the CAN 7 was not disposed of.
But mother, if the order mother CAN 7 was mentioned.
Yes,
Yes.
that's why it was mentioned
Mother,
specifically that the CAN 7 is not
I did
mentioned.
not open my mouth to go where for me. That is mother on my part. Mother, the CAN 7 is a formal application for amendment respect of title of respondent number 3. Your lordship kindly see paragraph 2 to paragraph 4 of my application CAN 7 of 2020. Further amendment in respect of title of respondent number 3 and address of respondent number 1 to 3. Further, I have narrated paragraph 2 KB. I have annexed the other parts.
It should be appear under to be mentioned. Otherwise,
Can-
for correction, it is not necessary.
Your lordship kindly first take the my application for amendment. Then I will go to the order. Like modification for or correction. But your lordship kindly my application for that. Lordship is seeing my lord CAN 7 application. The
Yes.
CAN 7 application my lord is in the title of amendment of the title of respondent number 3. Another original title is case and after the mother marriage was Monroe.
Yes.
Notary order. That is one part. Another part is address is mother table. Mother is Palchipur, post office Budayano, Navana, address is on basis of Aadhaar card is the column number 2.
Yes, I understand.
Yes, my lord. This is my lord, my application. Now, my lord, your lordship kindly turn to the award marked by your lordship at page 7, paragraph 70.
Yes.
My lord, your lordship reduced the amount from 10,70,000 to 8,50,000. 10,40,000. Now, my lord, 70, I am giving the just and proper compensation in this case to rupees 8,50,000. The award shall carry interest 6% per annum from the date of filing of the claim application, that is from 15 May 2009 till the date of deposit of the award put on 31st 7 2012. It appears that the issuance has already previously awarded master carry submitted. The office of the London Minister calculates directly to calculate the initial award passed by both the ministers as directed above, and these were the 7 8 statute interest of the payment number 1 and 3 5 3 equal accountancy to the police. There may be some residue account of insurance company same value that could interest to be funded to the property. Now, lordship kindly pause. My lord, generally, my lord, as per section 171, my lord, as per the statutory provision and also the my lord, the various judgments of the Honorable Appeals Court, my lord, the section says when the award is passed by the tribunal, the award must carry interest. If interest or the court fixed from the date of filing of the claim application till the date of realization. Well, your lordship is mentioning the from the date of filing of the claim application till the date of deposit. Well, the claim case was filed, that was mentioned, but still now my client has not taken valor any single part. Well, it should be valor. Well, I'm prepared before the lordship. Well, till the date of deposit of the award should be limited till the date of realization from 15/5/2009 till the date of realization.
Where is Mrs. Mukherjee?
Mukherjee, I have informed my lord. She says that she will join in the and also my lord, I have given notice to him. I asked her when she does not have any objection. To that extent, when my lord, your lordship kindly see Aruti Bej Barua. I have, my lord, no, your lordship is aware. My lord, I have two decision of the Honorable Appeals Court. My lord, section of the Honorable Appeals Court that the award shall carry interest of the date of filing of the claim application, the date of the realization of the date of this. Because my lord, the award was passed by the Appellate Court on 20 January 2024. My lord, from 2009 to 2024, the interest amount should be higher from the date of filing of the claim application to the date of.
Okay, I understand. Where is Mrs. Upadas Mukherjee? Otherwise, how can I pass the order?
My lord, your lordship, my lord, this is the simple, my lord. Yeah, my lord.
All simple payer are there.
Amendment may be allowed, my lord.
Amendment will be taken up another date, not for correction.
My lord, I have. My lord, my lord, in the morning, my lord, my son had.
In absence of learned advocate for insurance company, no order can be passed. You know.
My lord, if,
have you informed?
even if my lord notice is been given, my lord, he does
You have
not
served
pass.
notice.
Yes. I mean, your lordship may pass, my lord, possibly if she has any objection, she will come and say on Monday. my accused, kindly, my lord, rely on my accused.
Very well. Please take down.
Okay.
This matter appears for correction. Stop. It appears that the learned advocate Mr. Bonik also moved one application, also mentioned one application which is pending for disclosure, that is CAN 7 of 2023. Let the matter fixed on Monday under the heading of to be mentioned. Both the matter. I will pass the order on Monday. Okay.
Monday, my lord, Monday, I have a matter, my lord, because the commission.
Then Tuesday. Okay. Tuesday. The Tuesday for 19. Appellant is directed to inform the learned advocate for the insurance company regarding the returnable debt.
Okay.
My lord, Mr. Lal Ratan Mondal is for the respondents is engaged in another court. I pray for a short pass over.
What is this?
My lord, item 5, your lordship, my lord, with regard to that attachment of bank account, your lordship asked me, my lord, on the date yesterday, my lord, to inform Mr. Mondal, Shantu, so that my lord, he can come. Because your lordship was about to pass the order, but still your lordship, my lord, thought that his name appears in my lord, one of the.
Yes.
So I
What is your
informed-
submission?
Please kindly pray for a short pass over.
Passover.
Pass over.
How many time?
For 30 minutes.
taken here.
30 minutes.
30 minutes.
He's engaged in another court in court number
Okay,
8.
inform. I will take up the matter on
My
12.
lord, my lord.
Okay, next. Passover.
Seven, my lord, is the appeal of insurance company, my lord, my client does not wish to proceed with this appeal. Your lordship will kindly, my lord, dismiss it as not pressed. My lord, your lordship will kind enough, my lord, to keep this instruction in the file. And my lord, the statutory deposit which has been made, your lordship will kindly allow me to, my lord. My lord, the only first is given, my lord. My lord, interim stay was passed, my lord, but by that time, my lord, they had already executed the order and they had received the money.
Okay.
So, my lord, I do not wish to proceed any further.
Okay, please take down. Mr. Rakesh Singh, learned advocate, appearing on behalf of the Bajaj Allianz General Insurance Company Limited, submits on instruction that the insurance company do not want to proceed further with this appeal. Stop. Mr. Singh handed over the written instruction. Let the instruction be kept in the record. Stop. Mr. Singh commits that the interim order of stay has been passed by this court, but the appellant, but the claimant has already executed the order before the learned tribunal. Accordingly, further proceeding of the appeal is not necessary. Considering the submission and also considering the taking note of the written instruction of the insurance company, the instant appeal be and the same is hereby not pressed, disposed of as not pressed. The interim order of stay passed by this court on the earlier occasion is hereby also vacated. Stop. The the office of the Learned Registration High Court Calcutta is directed to refund the already statutory deposited amount along with the accrued interest on usual prayer. FMA 1035/2022 connected claim application disposed of.
I'm extremely blessed, my
They'll
lord.
send down at once.
Grateful to your lordship.
In this case, I have been appointed, my lord, to argue the case before your lordship, my lord. I am paying, my lord, only not today, my lord.
My lord,
I am not, Mr. Singh, Mr. Singh has already argued. And thereafter, my lord, I have been appointed.
This is a pattern matter.
Yes, yes.
my lord, Miss Ghosh was there. My lord, she literally forced me to do this matter. My lord, I did it, but then, my lord, for the point involved, my lord, she had then, my lord, approached Mr. Mondol to argue the case on her.
What is the matter?
My lord, this
My lord, the thumb.
Okay, okay, okay. Yes, got it.
Huh? My lord, yes.
So when can be done? Next
week
Friday?
I shall do it. Next week, I shall
Next
do it.
Friday.
Next Friday.
my lord, not today, my lord, would automatically, my lord, make it for next Friday.
No, next Friday. No, this matter
I shall
can
do
be
it, I shall
appear
do it.
on Monday also. Upgraded matter is less now.
Oh, yes. Spoken for people.
I shall do it. Monday also.
Monday. Very well, not today?
Not today.
So last week.
Okay, not today.
One item number 10.
No, today is the not date of upgraded matters.
I want to take a leave from you. I want to attend the one page there in the judgment page. Judgment. I again attend Xerox copy. Probably for that you will ask me to file application. I will grant the leave just now. I will do it here in the footage. My page here is it is ready, my.
What is this?
This page I have to annex.
Last page of the certified copy.
Yes, last page of the certificate.
Why you not attach this?
Why I am not attached? Because other things are there, that is why.
Okay, that is the dispute.
This is the problem.
So you have to deposit it on the department, not in the court.
Now, I tried to deposit in the department, but they.
Then I file an application so that I can direct the department to take consideration of that matter.
My lord, if you grant me leave, I can just now. I have brought
No, no,
everything.
leave cannot
I
be
can attend.
granted in this
They
matter.
were telling me to do it.
The
but-
department person will come here. How can I do this? This is the no. This is not the proper procedure.
No, send it to the department, telling them that you have granted me leave, I will do it there. That can be done.
Come on Monday. This today is not the upgraded matter.
Okay,
Come on Monday.
I am sorry to discharge you.
Next.
My lord, item number,
Lordship, counsel appearing on behalf of the insurance.
one second. Item number 10 and 11, my lord, has kept us as not this week, my lord. Previous matter, my lord. Item number 10 and 11. My lord,
I am not today taking any upgraded matter.
no, my lord, we are not submitting. We are not submitting for that matter, my lord. It was kept as not this week. This matter, my lord, Mr. Alam wanted to seek leave of your lordship to deposit the money beyond time. So my lord, if the Monday, if the matter is taken up, we can argue and he doesn't even have to deposit the money.
Yes, come on Monday.
Yes, because paper books and everything is ready. We'll argue the matter.
Yes, yes.
Grateful, my lord.
Your Lordship, counsel appearing on behalf of the respondent insurance company is not present today due to personal difficulty, Your Lordship. He has to take his mother to the hospital. So kindly, I pray for not today.
Who is appearing for the claimant?
Well, I am appearing for the claimant.
I think it was
Well, this matter is pertaining to that loss of consortium point.
Loss of consortium. This
Yes.
is ready matter today.
Yes,
I supposed to hear it today.
yes.
yes, Your Lordship, but actually, unfortunately, he has to take his mother to the hospital.
Very well. Then Monday.
Actually, it's
Yes.
Monday.
Monday.
Come on Monday.
Grateful,
Not
Your
today.
Lordship.
Who is there in the 15?
This is my appeal, my lord.
Yes.
Railway claims tribunals matter.
My lord, 16 minute, I am appearing on behalf of Union of India.
Yes.
My lord, appeal is filed in time. So your lordship, I am praying for a direction to call for the lower court record by special messenger. I will put the special messenger by next week. And your lordship kindly direct me to prepare the paper book in 3 sets, my lord. For the present, my lord, make it, my lord, out of the list, and I will given a liberty to mention the matter after preparing the paper.
Okay, please take down. The instant appeal is preferred against the judgment and award dated 1st of September 2023, passed by the learned Railway Claim Tribunal, Kolkata bench in claim application number such and such. Stop. The claimants have preferred the instant appeal against the award. Stop. The report of the stamp reporter suggests that appeal is preferred in time. Accordingly, appeal be formally admitted. Stop. The respondent, Union of India, is represented. Stop. Call for the record through the special messenger from the office of the learned tribunal. The cost to be borne by the appellant. Stop. Appellant is directed to submit the special messenger for cost within a fortnight. Stop. The department shall ensure that the LCR be reached to this court through the special messenger within Calcutta bench within 2 weeks after deposit of the cost of special messenger. Stop. On reaching such LCR, on reaching the LCR, the department shall verify it. On verification, if it is found to be complete and in order, the department shall serve a notice upon the learned advocate on record for the appeal within a fortnight. Stop. On receiving such notice, the learned advocate for the appellant shall prepare the informal paper book, at least 3 in number, at least 3 sets in number, containing pleadings and proof, both oral and documentary, of the LCR out of court, and file the same to the department after serving a copy of the same to the learned advocate for the respondent within 4 weeks thereafter. Stop. Okay, let the matter go out of the list. Party has liberty to mention.
For the sole respondent, so service is not required.
That's why I have not passed any order. Very well. Have you received the memo?
I find that.
Have you received the memo of the appeal?
No.
Then you have to serve it. The appellant is directed to serve the memo of the appeal to the learned advocate for the respondent appearing today. Stop. As the respondent has already made their appearance, so the notice of appeal upon the respondent is dispensed with. Stop. That's it. Liberty to mention.
My lord, copy of a paper book be also served.
Yes, I have directed.
Yes, lordship. ठीक है.
Yes.
Grateful to your lordship.
Give me item number 5.
I am for the respondent.
My lord, I had shown to your lordship, my lord, page number 11. If my lord will kindly come to. My lord, entire awarded sum, my lord, was deposited before this honorable court. My lord, then I had shown your lordship, my lord, page number 13. That is, my lord, the type is at page 13A. The last paragraph. my bank account, my lord, was attached.
Yes.
And then, my lord, I was, my lord, showing to your lordship, my lord, page number 16, 16, last two paragraphs. My lord, the last paragraph was, not in view of the above, all proceedings shall remain in state till disposal of the appeal. Either party should furnish any subsequent order in connection with the aforesaid appeal to enlighten this tribunal. My lord, since then, my lord, my account is attached, my money is, my lord, fixed over there. Lordship will kindly, my lord, allow my account to function, my lord, with regard to that amount. And let the attachment order, my lord, be state. And amount, my lord, account to be, my lord, function normal.
মানে
টাকা এখানে জমা আছে।
এটা এই কিন্তু ব্যাপারটা আমি বলি
হুম।
Yes.
মানে kindly see মানে first page of the application. This is an application praying for appropriate order.
Yes.
মানে kindly see the prayer. Kindly
Yes.
see the prayer. মানে vacating the attachment order number 4. So মানে this is the vacating application. This application was filed. মানে order was passed 2014. মানে kindly see the two orders. মানে after that order, High Court's order was passed. মানে they have not mentioned in the High Court. মানে I have my account already attached. How I paid the money before the register or before the register general. Kindly see, my lord. They have not come to the High Court, my lord, earlier, my lord. My submission is that, my lord, your lordship fix the appeal, my lord, and disposed it, my lord. Otherwise, my lord, I have not received any money, my lord.
What purpose your purpose would be served?
Yes, my lord. If
What
the
purpose would be served?
my lord, appeal
By attaching double amount?
not I have not intention to that.
Then
My lord,
what purpose would be served there?
my lord, appeal will be heard, my lord.
Appeal can be heard, no
Yes,
issue.
my lord.
Appeal can be
They have not taken any steps to hard out the appeal, my lord. Only for enjoy the stay, my lord. So, my lord, they have paid the money. I have not. What is the benefit of me, my lord? I am come to the
No,
court.
whether you have mentioned that this matter is pending since long,
Yes,
so
my lord.
this has to be disposed of.
My lord, they have not taken thereafter. My lord, whether kindly see, my lord, whether paperwork was filed, all are not take any steps, my lord. No, I am the respondent, my lord.
I understand you are the respondent. That's why you have the urgency to dispose of the appeal.
Yes,
You have to mention it before the court that this appeal should be disposed of earlier.
my client is so poor, my lord. Kindly see, my lord, the order. My client is so poor, my lord.
I understand, but what is the purpose would be served by attaching double amount?
Your the appeal, my lord. My lord,
Maybe 10 times
no,
amount will be attached. But what
attachment was done, my lord, prior to the deposit of money.
I understand.
What is the why they have not come to the mention in the High Court's order? My account was attached. If I paid my account in division bench order was there, my lord. After that, my lord, kindly see two dates of the order, my lord. High Court order was passed, my lord, on 28th April 2024, 14, my lord. My lord, before that, my lord, that the order was passed, my lord. On, my lord, first March 2014, my lord. From 1st March 2014 till date, my lord, they have not taken any step. Your lordship heard the appeal, my lord. Any day, my lord. I have no objection.
I don't have the determination to hear the appeal. Otherwise, today I can hear it out.
Yes.
But I don't have the determination to hear it out. This is the matter of 32, code number 32.
No,
If you are ready, it can be heard out. I have no objection to hear any urgent matter.
Milord, let this matter, Milord, I'll personally mention this matter, Milord, next week before the Honorable Division Bench. Let the Milord Honorable Justice Gupta, Milord, let Mr. Gupta fix up the bill. Honorable Justice
Yes.
Gupta fix up the bill. Let Milord give me the notice. Let he mention the matter. Milord, I never objected, Milord, for any hearing matter to be taken up. Never. My Lord knows that, Milord. Milord, he is not against this double deposit. He says that let the amount be released. It's not that he only wants, Milord, the early hearing.
Then, my lord,
I never objected.
High Court has released something in my favor, my lord. I will support, my lord. If I died, my lord. If I died, my lord.
Now, have you made any prayer that something is for 50% or 5 lakh can be
My
disbursed.
my client unfairly expected to dispose of the appeal, will get the money, my lord.
Since 2014, the matter is pending at yearly. How is he is expecting? 10 years has passed.
Only consider, my lord,
No
my predicament
application
of
on
my
your
client.
part to receive the amount or like that. How can I understand your urgency? You keep mum as well as the insurance company. I can understand the insurance company has some benefit to keep mum, but you have to move it. You must have filed an application to receive some amount of money as it was deposited. You understand? You must have filed one can to get some amount. Okay.
Hmm.
Please take down can 3 of 2024. This is an application for appropriate order filed by the Appeal and Insurance Company. Learned advocate Mr. Singh appearing on behalf of the insurance company submits that the instant appeal is preferred against the judgment and award dated 25th September 2013, passed by the learned judge, Motor Accident Claim Tribunal, Purulia, in MSC case number 57 of 2011. Stop. After filing of the instant appeal, the insurance company filed an application for stay of operation of the impugned award, and by virtue of the prayer of the insurance company, the division bench of this court has passed an order on 28th April 2014 and directed the insurance company 14 by staying the operation of the impugned order and directed the insurance company to deposit the entire award. By virtue of such, in pursuance of such direction, the insurance company has deposited the entire awarded sum of rupees 27,83,537 on 16/5/2014. Stop. Mr. Singh submits that after such deposit, it comes to the notice of the insurance company that the claimants have preferred one misexecution case number 12 of 2013 before the learned tribunal to execute the award. Stop. In pursuance to the order of the learned tribunal dated 1st of March 2014, the bank account of the appellant has been attached in respect of awarded sum of rupees 27,46,753 in pursuance to the provision under Order 21 Rule 46 CPC. Stop. The insurance company, after having knowledge of the same, moved before the learned tribunal to freeze the bank account as the entire awarded sum has been deposited to the before the learned Registrar General High Court Calcutta by virtue of the order of the division bench. Video order dated 18 of April 2017, the learned tribunal is of view that as the operation of the impugned award has been stayed, so it would be not possible for the tribunal to pass any order. Stop. At this situation, the instant can application being can 3 of 2024 has been preferred for appropriate order. Stop. Learned advocate Mr. Mondal, appearing on behalf of the claimants, submits that the instant appeal is preferred in the year 2014. Stop. The order of stay has been passed after the filing of the appeal, but the insurance company has taken no steps to dispose of the appeal promptly. Stop. He further submits that the claimants are suffering without getting any amount since long 10 years. So the appeal may be disposed of as early as possible without passing any appropriate order. Heard the learned advocate, peruse the application, also clear therein. Stop. It appears that the application seeks the prayer of bracket the order of attachment dated 1/4/2014 and subsequent order dated 18/4/2017 passed by the learned tribunal. Stop. The situation prove that the insurance company, the double amount of the award has been secured by the insurance company once before the once by the order of the learned tribunal, once by the order of attachment of the learned tribunal, and thereafter by the order of stay of this court. Stop. It appears that no, stop. It further appears that the appeal is pending since 2014, but the appellant has not made any prayer for getting any award, any portion of the award from the office of the learned Registrar General High Court Calcutta by making a specific application. Considering the same, it appears to me that the appeal should be disposed of first, disposed of earlier. However, next, in considering the fact that the principle of double jeopardy has been affected in this matter, so in my view, the order of attachment passed by the learned tribunal need be vacated. Stop. The order of attachment is hereby stop. The order passed by the learned tribunal on 1st of March 2014 attaching the awarded amount, attaching the bank account of National Insurance Company Limited with the Punjab National Bank, Asansol branch, district Board 1, in respect of account number 0032 0021 003827. এখানে চেক করতে হবে, এখানে আছে page 14,
Not page 14A at the top.
page 14. ঠিক আছে, কি বললাম বলো? Bank account of National Insurance Company Limited, Punjab National Bank, lying at Punjab National Bank, Asansol branch, district Board 1, being account number such and such, is hereby defreezed. Stop. The insurance company is at liberty to operate the said bank account according to their wish. Stop. It further appears that next paragraph. It further appears that the instant appeal is pending since long, so the insurance company is directed to take effective steps so that the appeal may be disposed of within April. Is it possible within April? Paper books?
Lord, paper books are not ready. Lord, I had furnished Lord Tolowana and postal cost upon the owner of the vehicle Lord, on 3 occasions.
Let be there on 3 occasions you have deposited.
Lord, the last Lord, of course, Lord, the last one was in the year 2015, 4th of December. Postal cost of rupees 51. If Lord, my Lord has got the original file. 4th of December was the last of those, my lord. Postal cost of 51 with written up notice forms, my lord, were furnished for service upon respondent number 5. Because, my lord, in this case, my lord, this pay and recovery aspect is involved. Otherwise, my lord, I wouldn't have asked for this one. My lord, before that, February 2015, postal cost deposited. Before that, May 2014, written up notice form Tolovana deposited. My lord, 3 clear my lord, deposits were made before my lord's department. My lord. I've got the numbers, my lord, and the entries of each one of those.
One order was there by the learned registered administration, lodging,
My lord, I have also
on
furnished
11th of March 2024.
lordship.
The appellant is directed to take fresh steps
11th of March.
causing service of notice of appeal upon the respondent number 5 by speed post with AD within 2 weeks.
My lord, 11th of March, my lord, was only 3 days back. But your lordship will, my lord, on 3 separate occasions, my lord, written up notice forms and postal costs were furnished. I have also deposited, my lord, a special messenger's cost of 600 for bringing below the lower court records. That also has been done. My lord, twice in 15 and once in 14, I've deposited, my lord, this written up notice forms along with, my lord, the postal
Yes,
cost of
yes.
3 times, my lord, I have
It is appearing, but the direction is there upon you on 28/6/2016 to file a fresh step.
My lord, I'll, my lord, in view of this last, my lord has, my lord, just, my lord, read that
Yes,
in 2014, my lord, I'll do this again, my lord, today or by Monday, again, my lord, I'll do it.
yes, you take steps. Now, this
Lord,
is the last order is 11th of March, 2024.
3 days back.
Yes, this is the replica of order dated 28/6/2016, wherein you are directed to take a fresh step. upon
My
that.
lord, before 16, thrice
Here,
I have
yes,
deposited postal
yes,
costs
yes.
and, my lord, everything
But
done.
but the
My lord, I'll do it again. I'll do it again. My
but
lord,
the report is not coming. This
I'll
is
do
the
it by
issue.
Monday itself. Maybe today or by Monday, I'll do it again. But it's not that, my lord, I'm not trying. But thrice I've deposited a special messenger cost for bringing lower court records.
So you prepared the paper book. Have you the copies?
No, my lord, no part.
You don't have the copies.
All copies are not ready.
You prepared the paper book and come with ready, so that matter can be
If
proceeded.
Yes, my lord, then my lord, I prepare the paper, only paper book. Regarding service of the respondent 5, my lord, they will.
That has to be done.
Okay, keep on.
Insurance company as well as the claimant is directed to take effective steps so that the appeal may be disposed of within the before the ensuing summer vacation. Before the ensuing summer vacation. Stop. I make it clear that though the direction of preparation of paper book is made upon the appeal and insurance company, but for the speedy disposal of the instant appeal, the informal paper book may be prepared by the claimants.
Which they agree with.
Yes.
Otherwise, no.
Okay. No, I don't pass like that. Only direction. Okay. Very well. Accordingly, Camp 3 of 2024 is disposed.
Deep level.
I'm extremely grateful to my lord. I'm indebted to your lordship. Thank you.
Mr. Singh. দাঁড়াও yes শেষ acting
কি পয়েন্টে আছে?
সবগুলো এই তোমার পেপার বুক লাস্ট আইটেমটা
এটা কোন মামলা?
item number 17 to 23 is not a similar matter, not out of same accident. And you should take up the matter 22, which is not paper book is complete. Other matters not paper book, not complete paper book, but all the papers are in 22, item number 22,
Item number 17 to
22, 23.
23. Yes. 17, 18, 19, 20, 21, 22, and 23.
22, 23 may be taken up first.
22 and 23. And other matters?
Same matter, my lord. That will be taken up. All the documents are here in this appeal.
এটা আমার কপি?
Now, also,
এটা জজ সাহেবের কপি?
Hmm.
দাদা এটা জজ সাহেবের। এটা আইটেম নাম্বার কত এটা?
22.
Right. Lord, I'll tell your lordship, Lord, what is the
Yeah. 22, 23.
আরে না পড়ে এলে আর এটা আমার কপি।
তোমার পক্ষে
ম্যাচ করছি জজ সাহেবের সঙ্গে।
নিশ্চয়ই ম্যাচ করবো but in the appeal, my lord, Mr. Singh raises a question that the deceased was traveling in a, my lord, goods vehicle with the goods as a owner of the goods of the owner, as an employee of the owner of the goods. This is the only point to be decided by lordship.
My lord, I'll tell
That
you,
is
Lord.
that the agent of the lord.
তোমার favorite
বলো।
বসে যাও। My lord, in a truck, a number of laborers were going. The truck, my lord, met with an accident. There were a number of casualties. Rising out of those casualties, my lord, different claim cases were filed. One single accident, my lord, awards were passed, my lord, respective awards were passed against the insurance company. New India is the appellant before your lordship. Arising out of the four separate, my lord, awards passed by the London Tribunal, my lord, four separate appeals have been preferred before your lordship, which are today appearing in your lordship's list. My lord, one of those, item number 22, my lord is taking present.
Yes.
The order passed in 22, my lord, would be governed by the other three appeals, my lord. My lord, the point, what I had raised in this appeal, my lord, whether the victims who were going in that truck, whether they were covered under a policy of insurance or not. The status of the victim, what were they? My lord, your lordship knows, my lord, under section 147, my lord, insurance company issues coverage. As far as the goods vehicle are concerned, my lord, after the amendment of 1994, the owner of the goods, my lord, I'm talking about the goods vehicle. My entire case is confined to goods vehicle, lorries, trucks, tempos, those who are used for commercial purposes, my lord, for carrying goods. My lord, the insurance coverage is given, my lord, statutorily to the owner of the goods. Well, prior to that, it was prior to the amendment, it was not there.
Yes.
But after the amendment, because it is given to the owner of the goods or his authorized representative. In this case, the victims were the employees of the owner of the goods.
Yes.
Those employees, my lord, the statute does not say that they are covered. Employees of the owner of the goods cannot be covered. And in any event, my lord, if the goods are going, then how many employees of the owner of the goods would go? My lord, it's not that. For example, my lord, one bag full of potato is being loaded in a truck. Let's say, my lord, one bag. One bag full of potato, my lord, would have 600 potatoes in this. So that doesn't mean, my lord, that 600 potatoes, for each potato, one authorized representative of the owner, 600 people can go, or not for that matter, 60 people can ride on that truck and then say that, yes, I being the authorized representative of the owner of the one piece of potato. There is a judgment of Supreme Court, my lord, that those authorized representatives, or even for that matter, owner of the goods, has compulsorily to travel in the cabin of the truck. These laborers, they were not in the cabin of the truck. Be that as it may, my lord, they were not covered, and moreover, it was an act policy. My lord, act policy only covers the statutory liability, nothing more, nothing less. Statutorily, my lord, I am not giving any insurance coverage to the employees of the owner of the goods, which were there in that truck. Owner of the goods was covered, statutory liability. Owners of the goods, authorized representative has.
What is the amendment? Only owner?
Owner
or the
with
employee?
owner and my lord, your lordship will kindly, my lord, have this section 147
Yes.
Motor Vehicles Act.
Motor vehicle. আরো সাইডে তারপর সিপিসি পার্ট
Section 147, 47, my lord.
Yes.
Requirements of policies and limits of liability. What is there?
Yes.
In order to comply with the requirements of this chapter, a policy of insurance must be a policy. This mandate. It has to be. What has to be? It's issued by a person who is an authorized insurer. But my client is an authorized insurer. Yes, I qualify. B. Insures the person or classes of persons specified in the policy to the extent specified in subsection 2.
Yes.
Prior to that, my lord, I am covering, what covering? Against any liability which may be incurred by him. My lord, that is the owner of the vehicle. Liability incurred by him, I am covering that. In respect of the death or bodily injury. This is what I am covering. Then, injury to any person. Now, your lordship, the bracket has started. Lordship, this bracket there, right?
Yes.
Injury to any person. So this has come up by way of an amendment.
Including.
Yes. Injury to any person, including owner of the goods, which was not there earlier.
Yes.
So now, with this amendment, I am covering by statutory policy. The statute mandates me cover what? To the owner of the goods. My lord has read that, and or his authorized representative carried in the vehicle. So these two have been added, which were not there earlier. No dispute about this. So I am giving coverage to the owner of the goods in a goods vehicle and his authorized representative. As I gave the example below, one bag full of potatoes going, or maybe the truck is loaded with the potatoes. So either the owner of the potato would go, I have to give coverage. Prior to the amendment, it was not there.
Yes.
Or one of his authorized representative, my lord, that representative, my lord, would also be covered. It cannot be just, my lord, the potatoes are loaded. My lord, owner would be worried that my potatoes, I do not know where it would land, the exact mandi or the market or to the shop where it is supposed to go, or nobody steals it in between. So one authorized representative is also allowed. But my lord, the judgment is they have to sit in the cabin. In this case, this was not done. My case is the persons, the four persons, not four different cases, four different cases. They were the employees of the owner of the goods. Salary paid. They are neither the owner nor the authorized representative with regard to this. Authorized representative, you cannot have four authorized representatives in one track.
Yes.
So, my lord, this is what, my lord, my appeal is all about. I'll take my lord to the judgment, to the award. Your lordship will kindly say, my lord. Then I am
Yes.
against the death of or bodily injury to any passenger of a vehicle. My lord, I am not hit by this. This is the passenger of a, my lord,
Transport vehicle.
Then the proviso. Policy shall not be required. Not what policy? It is the act policy or the statutory policy, which is in this case is. I am not required to cover. I am an insurance company. It's not required to cover what? To cover liability in respect of death arising out of and in the course of his employment, the employee of person insured by the policy, or in respect of bodily injury sustained by such an employee arising out of and in course of his employment, other than a liability arising under the workman compensation. This says in a if I can define this in simplified words. Of course, I am not hit here also. That insurance company would cover the liability, statutory policy. I'm sticking to statutory policy, not extra coverage given, not extra payment.
Yes.
Insurance company would also cover the liability of the employee of the insured. Since it is a motor accident policy, it is a motor vehicle, employee of the insured would necessarily, for Motor Vehicle Act, would be either the driver of the insured, owner of the vehicle, or khalasi. Only for those two, this would be applicable here. To the extent, if no extra premium is given, up to the liability of Workman Compensation Act, up to that liability, insurance company is giving the coverage. A little confusion, I'll remove that also. A person, a driver or a khalasi has got two options. Either to go before the Workman Compensation Court or to come up, for the motor vehicles.
Yes.
The motor vehicles. Only these two get this advantage. Others do not get this advantage. The driver of the khalasi can go against his employer, against the WCI or Employees Compensation Act, as now it's.
Yes.
Other third party, they are not covered under the WCI, knows, because the question of employment comes in. But here it comes in. So in those cases, in the cases of a driver or a khalasi, although it is not related to this particular case, it's just for the discussion I'm explaining this. A driver or a khalasi has got two options. Section 167 of the Motor Vehicle provides that option, that you can approach either WCI Act or Motor Vehicle Act, but under the Act policy 147, I says, proviso says that the liability of the insurance company with regard to that particular driver or that particular khalasi would be covered only up to the extent of its liability under the WCI Act.
Yes.
If, by way of an illustration, I can make a little more lucid. I am the khalasi of a particular truck. I suffer injury in an accident. I have two options. I can go before the Workman Compensation Court against my employer, or I can go to the Motor Vehicle Act, wherein I'll be paying for compensation from my employer who would be indemnified by the insurance company.
Yes.
Under the Workman Compensation Act, your lordship the schedule is there. I get a compensation by way of calculation. It is shown, because it is simple mathematical calculation. I get 3 lakhs of rupees. The same me, if I approach Motor Vehicle Act, I can approach either one of those, either there or there. If I under Motor Vehicle Act, I find that my compensation comes to 6 lakhs of rupees. Had I gone to WC, I would have got 3 lakhs or 4 lakhs, let's say. Under Motor Vehicle, I would have got 6 lakhs. By virtue of this 147 proviso, the liability of insurance company under these Act policy, because mandatorily covered, they are. Insurance company here under Motor Vehicle Act would give me the coverage of 4 lakhs only. Learned tribunal would pass an award of 6 lakhs. Calculation, Mr. Singh's got 6 lakhs. But the liability of the insurance company would be confined to 4 lakhs because the proviso is there. The statutory liability, the balance 2 lakhs would be paid to me by my owner personally.
Okay.
I get 6 lakhs, but the liability of insurance company would be confined to 4 lakhs. We are not hit by this. This is only for my lord's understanding. I see it there. I am only 147I. 1I. Now, the facts of this case. Since the victim were the employees of the owner of the goods, they were hit by 147AI. They were neither the owner, they were nor even the authorized representative of the owner. They were the employees. So I am not liable to give any insurance coverage to those. Now, what happens in this case? Now, I'll argue against myself. in favor of minority. If those laborers are, my lord, neither the owner nor the employee, nor the, my lord, the authorized representative, they were, my lord, traveling, my lord, at the backside of the truck. What are they? What is their legal position? If the moment I put this question to myself, they are the gratuitous passenger. Had they been neither laborer, had they been neither owner of the goods, had there been nobody, they would have been a simple passenger. Let me take even the bus case. Somebody going on the road, okay, fine, you come up, you give me 10 rupees, the driver says, get out. A simple passenger. Then this dispute of whether they were the owner, whether they were the authorized representative, or whether they were employees, these were also discarded. A simple third person getting onto the truck, not entitled to any coverage under Act policy. Then what was that person? That was a gratuitous person. A gratuitous person may not, I would not be troubling your lordship much on those. We don't, the philosophy or the principle of pay and recovery.
Yes.
This was just to give the background to my lord, to make the act clear to fair lordship. These laborers were in a better footing than that individual traveler on the road who would be hopping onto the truck. They were at least something. But that something also does not entitle to have the insurance cover in terms of the act. So ultimately, they were the gratuitous passenger. And in view of the gratuitous passenger, it's starting from budget or till date with insurance company 149 to defense, pay and recovery is there, because you can plan pay and recover order in each of these cases. Now, this was the entire fact. In these facts, I'll invite Malwa to go through the award password. But this was the crux.
Yes.
But if I'm wrong, anywhere, my learned friend would kindly correct. I've done 22 hours. It was under section 163 capital A. An award of 4,25,500 was passed. I have deposited this entire amount along with interest with an excess deposit of 25,000, which is not a part of this award. For this honorable court. The judgment of the learned tribunal judge. Is at page. That page number 10. Page number 10. Judgment of the learned tribunal.
Page 22.
Page 22. কোনটা বের করেছে?
This is
Page 22. Page 22.
What is this?
পার্বতী বর্মন। এটা ধরে
পার্বতী বর্মন।
এটা আলাদা, তুমি পরে নিয়েছো। একই জিনিস তুমি এটা তো তুমি কোথায় রেখেছো তুমি? ওটা অন্যটা লিখে দাও।
এটা সন্দেহ এটা আছে পার্বতী বর্মন। Lord, I'm sorry, just one more. Rama. Milord, the award passed by the learned tribunal, Milord, is at page 22. My lord is correct, Milord. I'm sorry, Milord, for delay this. This is an application under section 163 capital. Is my lord there, Milord? Filed by the petitioner claimant, as stated above, claiming compensation to the tune of rupees 4,60,000 due to vehicular accident death. Milord, in all these cases, Milord, I have deposited the compensation amount with accrued interest before my lord's court. In all these 4 cases.
Yes.
4,60,000 due to vehicular accidental death of Polash Burman caused by the offending vehicle bearing truck number so and so 25. The fact of the said application in brief is that the respondent number 3, that is Kalpataru Power Transmission Limited, is a construction department. Right? Under the West Bengal State Electricity Board, has been conducted from some APDRP reconductoring device allocated by the SENCM Jalpaiguri circle number so and so, approval dated so and so, in reference approval memo number so and so, with the Dinhata subdivision. The victim, along with 7 other laborers, had been under the said Kalpataru Power Transmission Limited. Note, this was my case. Your Lordship will kindly underline that. Take note of this, my lord. The victim, along with 7 other laborers, had been under the said Power Transmission Limited. They were, my lord, the employees of that Kalpataru. They were neither the owner nor the authorized representative. They were the employees of this Kalpataru. Why Kalpataru comes into the picture, my lord? Because Kalpataru had hired this way.
Yes.
So that is why, my lord, I say the employees are not covered under 147, and I have shown to your lordship. On 3rd of July 2006, the said Power Transmission Limited hired a truck. So, my lord, Kalpataru hired the truck, which is insured by my client. Being number 25 from Kuch Bihar Truck Owners Association for carrying 34 PCC poles. The poles, the electrical poles, I believe, they were loaded into this. 8-meter long from so and so at the rate of rupees so and so per piece, on condition that the said poles, it should be POLES. Said poles will be loaded and unloaded by their own laborers. Their own laborers, employees. As per condition as mentioned above, the said poles were carrying by the said truck with 8 laborers for loading and unloading of the said poles from Setai to Dinhata. But on the way, when the said truck reached at village Barakoimari near Sitlukuchi police station, the relevant time, another vehicle coming from opposite direction, the said truck was given opportunity to cross the said vehicle with high speed in a rash and negligent manner, and as a result, the driver of the said alleged truck lost his control over, as the said truck was capsized in the side of the road. All of a sudden, the 3 laborers out of 8 were jumped in another side, and the rest 5 laborers, including the victim, along with said ECC poles, also fallen down in the other side, and the said 5 laborers were sustained multiple injuries all over their person by pressure of the said poles and died on the spot instant. The said laborers, including the victim, were the employees of Kalpataru. Your Lordship, it is very clear that they were the employees of Kalpataru Power Transmission Limited. The victim was the sole earning member, and the petitioners are dependent. Victim was a laborer by profession, used to earn rupees 3,000. The petitioners are claiming 4,60,000. Notice was served upon the opposite party 1 and 2. They contested the claim, filing written statement. OP number 1, Lord, OP number 1 here. Lordship will kindly take note. Note is the owner of the truck. Have no cause of action. The claim petition is not maintainable. Petitioners no cause of action. Claim petition is bad. Kalpataru is a necessary party. Respondent denied. Statement denied. Carelessness denied. 163A, my lord, these things would not matter once the policy is and the insurance is admitted. My lord, case is not maintainable. Then, the insurance company stated that OP number 2, that the no cause of action against this. The claim petition is barred by the principle of estoppel, waiver, and acquiescence. Claim case is barred. Claim case is not maintainable. Lack of necessary documents. A statement made in column number 7 so are denied. Too strict proof. The age is denied. Income is denied. Nature of injuries denied. False and fabricated. No third party involvement. The statement made in so and so. Millard, the driving license disputed. Millard, in written statement, Millard, all necessary denials, Millard, are there. Not liable to pay compensation. As Millard, this is the important note. This respondent is not liable to pay any compensation. Millard, I'm in the middle.
Yes.
As the said owner has violated the mandatory condition of insurance policy by carrying at his passengers. The answering respondent also denied the content of paragraph number so and so. The amount of compensation is high, not part. No negligence. Petitions are not entitled. So, my lord, this I have taken the plea, my lord. I have argued. The learned tribunal judge has recorded this. My lord, thereafter, my lord, the issues were framed. Exhibited documents, my lord, are at page 26, internal page 5, certified copy of FIR, postmortem, insurance policy, birth certificate, voter ID card. To prove the petitioner's case, my lord, PW1 and PW2 appeared. As far as the insurance companies was concerned, my lord, there were no representations. My lord, issues decision. My lord, for the sake of brevity, all are taken together. My lord, now I'm at page number 27, internal page 6. Is under section 163A. Petitioner stated that, my lord, the entire petitioner's case is made out there. My lord, there were 8 laborers. It was hired from the Kuch Bihar Truck Owner Association. The rate is given, the timing is given. My lord, it is stating that 5 laborers sustained injury, they died. And my lord, the said laborers, including the victim, my lord, the last 5th line. My lord, page number 27, last 5th line.
Yes.
The said laborers, including the victim, were the employees of Mrs. Kalpataru Power Transmission. Victim was a laborer. He used 200 rupees 3,000. My lord, page number 7. Heard arguments. My lord, is there, my lord? Page number 7 at the top.
Yes.
My lord, now, my lord, the finding of the learned tribunal judge. Heard arguments. Second paragraph at the top. Carefully peruse the document. At the time of argument, learned advocate for the OP2 submitted and admitted that deceased was one of the laborers of which was carrying vertical post. He further submitted that vehicle was proceeding at normal speed, crossing capsized. My lord, I'm rushing, my lord. PW2 Adhir Burman was, my lord, PW1 in this case, my lord, was the widow. The first witness of the
Yes.
claimant was the widow, and my lord, the second witness was eyewitness, PW2. PW2, my lord, Adhir Burman was one of the laborers. My lord, and the insurance policy was valid. Photocopy of I-card. Victim was Dave laborer. My lord, it was proved. The last paragraph, page 28, at the time of argument, learned advocate for both sides referred several decisions, state of the state and apex court to avoid perplexity. My lord, the references, my lord, are not there, of course. In view of the foregoing observation, page 29, second paragraph, it is concluded that petitioners have been able to prove their case, adducing evidence coupled with the exhibited document. Victim died at the age of 30 years, so applicable multiplier is 18. My lord, the calculation is made. Total, my lord, award is 4,49,500. My lord, that is the total award. My lord, with totaling so and so, the last part is 6% from the date of filing of the claim case. My lord, after this, my lord, your lordship will kindly come to certificate of insurance policy.
Yes.
My lord, this is the entire case. My lord, I'll invite my lord to prove my case, my lord, at page number 44, which is the insurance policy. Lordship will kindly come to that, page 44. Is my lord there, my lord? My lord, on the right hand side, my lord, first, second, third, fourth, fifth or sixth line, your lordship will kindly say liability only. My lord has taken note of that, my lord.
Act policy.
Act. I'm deeply aware, your lordship. My lord, this liability policy is also, my lord, at times referred to as act. What is act? Act policy, my lord, is the policy which statute mandates me.
Yes.
That if
Only according to the statute.
yes, only according to the statute. If you want any extra coverage, then you take in addition to that.
Yes.
You want personal accident coverage, you want coverage against earthquake, you want, my lord, the vehicle, my lord, some this, that, whatever not, my
Yes.
lord, for the, my lord,
Drowning,
whatever.
everything.
The whole world is open.
Electrified,
Yes,
everything is.
whole world is open, whatever you want. But this liability policy is confined to what statute mandates you statutorily. You have to cover.
Yes.
So, my lord, I have, my lord, requested your lordship, my lord, and I have taken my lord, my lord, through section 147. What statute mandates? This employees of the owner of the goods statute does not mandate. If a statute does not mandate me, and if this is an act policy which is issued only in terms of the statute, then I have not covered them.
Yes.
So if I have not covered them, then I go back to my argument. Then what are they? I'm not liable to pay compensation. I'm not liable to pay compensation. Then where does it lead to? This was the line, what I was arguing against myself. It leads to that they are getting dismissed.
Yes.
Of course, there is one Supreme Court judgment wherein it has been stated, this is again the straight judgment, that insurance company not to pay. Sanjay Kumar Sharma, not I. Yes, it's there. Sanjay Kumar Sharma. No direct travel, your lordship. This says insurance company not to pay, but still, this is a division bench judgment of Honorable Supreme Court. But in view of this is what I said is straight up. Otherwise, in all cases of wherein the 149 defense is there,
Yes.
starting from driving, whatever the defenses are, there are 6 defenses available. In every case, the pay and recovery is. আরেকটা copy আছে? আচ্ছা। Paragraph 2 is the fact which is identical to my fact. The centripetal issue that emanates from consideration in these appeals is whether the insurer is obliged under law to indemnify the owner of a goods vehicle when the employees engaged by the hirer of the vehicle. Employees engaged by the hirer of the vehicle travel with the owner of the goods on the foundation that they should be treated as employees covered under the policy issued in accordance with the provisions contained under section 147 of the Motor Vehicles Act or brevity. Identical, same position. Truck was hired, paragraph 3, by one Durga Singh, who was traveling with 2 of his laborers. When the vehicle was moving from there to there, met with an accident. The laborer and Durga Singh injuries and succumbed. Durga Singh was the owner of it. He took 2 of his employees, 2 employees hired by him. So Durga Singh is covered, being the owner, but his 2 employees, they are not covered. This is what this judgment is on.
Yes.
Paragraph 24 is the finding. Hence, all these details, 24, it is worthy to note. How is that?
Yes.
It is worthy to note that subclause RC refers to an employee who is being carried in the vehicle covered by the policy. I have requested your lordship to go through this. I see. Such vehicle being a goods carriage, an employee has to be covered by the statutory policy. On an opposite reading of sections 147 and 167, the intendment of the legislature, as it appears to us, is to cover the injury to any person, including the owner of the goods or his authorized representative, carried in a vehicle, and an employee who is carried in the said vehicle. It is apt to state here that the proviso commences in a different way. A policy is not required to cover the liability of the employee except an employee covered under the 1923 Act, and that too in respect of an employee carried in a vehicle. To put it differently, it does not cover all kinds of employees. Thus, on a contextual reading of the provision, the schematic analysis of the Act and the 1923 Act, it is quite limpid that the statutory policy only covers the employees of the insured, either employed or engaged by him in a goods carriage. Not employees of the insured. In this case, they were not the employees of the insured. They were the employees of the owner of the goods. It does not cover any other kind of employee, which is our case. And therefore, someone who travels not being an authorized agent in place of the owner of the goods and claims to be an employee of owner of goods cannot be covered by the statutory policy, and to hold otherwise would tantamount to causing violence to the language employed in the statute. Therefore, we conclude that insurer would not be liable to indemnify. This is the appeal. Sanjeev Kumar Sharma, Sanjeev Kumar Sharma, is the owner of it. Presently, for the sake of completeness, we shall refer to the policy. The policy states that insurance is only for carriage of goods and does not cover use of carrying passenger other than the employees not more than 6 in number coming under the purview of the 1923 Act. The language used in the policy is so and so. On a bare reading of the opposite policy, there can be no iota of doubt that the policy relates to the insured and it covers 6 employees other than the driver not exceeding 6 in number, and it is statutorily and is statutory in nature, which is our policy is liability. It neither covers any other category of person nor does it increase any further liability in relation to quantum. In view of the opposite, we repel the contentions raised by the learned counsel for the appellant, and as a fallout of the same, the appeals being sans merit stands dismissed without any order as to cost. We don't know, Your Lordship will kindly think out what had happened earlier in this case. This appeal, this SLP was dismissed. Paragraph 4, Miller. Heirs of the deceased person filed separate claim cases.
Yes.
Paragraph 5, Miller. Tribunal came to hold that the victim were covered as per the insurance policy. What does it that, Miller? Tribunal
Yes.
passed the award in favor of the claimants. Paragraph 6, being aggrieved, the insurer preferred the appeal. Paragraph 6.
Yes.
Learned single judge allowed the appeals. Fourth line, third line.
Yes.
Wherein the legal representatives of the deceased employees were the claimants. As far as the FMA 178 is concerned, High Court concurred with the finding that Durga Singh was the owner of the goods. Therefore, the insurer was liable to pay compensation to the owner of the goods. As far as the insurance company had deposited the amount, budget for another, the direct insurance company, as far as the amount shall be of the insurer by initiating his proceedings for the tribunal, as the benefiting the owner of the. Beloved, in this case also, owner of the goods, paragraph 6, beloved, is important paragraph. Owner of the goods, beloved, was entitled to receive compensation. Durga Singh.
Yes.
And his 2 laborers, his 2 employees. High Court said that no, insurance company is not liable, but the principle of Baljit Kaur was applied and the direction of pay and recover was given.
Yes.
Ultimately, it is coming into the force. Owner became unhappy that why recovery from me. He went to Supreme Court. This SLP. Supreme Court said that no, whatever is order High Court has passed, pay and recovery right given, let that be there. We are not going to this SLP was dismissed. So even by the dismissal of this appeal, wherein the contention of insurance company of no liability was accepted, it was held that insurance company is not liable. Still, paragraph 6, Baljit Kaur's principle was applied and the pay and recovery order was passed,
Yes.
which was not changed by Supreme. So, what I stated earlier, this way, that way, I win the case. Supreme Court says you are not liable, full stop, period, and then says, okay, fine, you pay and then recover. So this is principle here, this is the entire, starting and finishing of the case. I hope, my learned friend would not be able to improve on what I have said. I would be praying, that the amount, the entire compensation amount which is deposited here, here, I have made 2 deposits. I have deposited 25,000, and then thereafter, Honorable Justice Dipankar, the division bench, as his lordship then was here. In some of the cases, they specifically asked us that you have deposited a statutory amount, keep it separate in a few of the cases. And then again, by a separate deposit, you make the entire award and the interest thereof. Let the statutory deposit be kept segregated. This is one of those cases, wherein the statutory deposit was an extra
Yes.
deposit here, and the entire compensation amount with the interest was deposited before this honorable court. My lord, 4,49,500 was the awarded sum. It's again, my lord, 163 here. I have deposited statutory deposit after segregating. My lord, the entire awarded sum with interest 7,58,066 before your lordship, which is inclusive of all interest. Now, my lord, another question comes in this in view of this amendment. 166, 163, whether there is accurate
Put Mila Halde.
once Mila, the Mila, huh? Cross है, because cross is there. It is appearing in the list. So, your lordship, that would be there. The right of recovery, your lordship will kindly come. My lord, I conclude. I don't know if it will anything more has to be said. So, thank you to बोल दो मेरे को. But yesterday he forced me to do a matter. I was not ready. That insurance policy coverage matter. He is very annoyed.
I mean,
Why?
No,
Why did you make it?
why you take the policy? Then no question panel.
He would be happy. I think.
Of course,
Let me find out the other matters. This is the item number
22.
22. 23.
Parvati Burman. Parvati Burman.
22 and 23.
Lordship.
Parvati Burman.
Parvati Varma. And 17, 18.
17, 18.
19, 20.
But 21, there is no cross.
21 and 22, 23. All matters are the same accident.
Same accident. Whole
Same
accident. Whole evidence. Not in that the same truck.
Okay. Very good.
I'm very sorry, I could not include the cross appeal in the paperwork, but it is in the list. It is appearing in the list. It is appearing in the list.
Which?
Cross appeal.
Cross appeal is appearing in the list.
Cross appeal appearing in the list. Okay. 23.
23 is the cross appeal.
Yes. I could not include it in the paperwork.
Okay, okay, okay. Okay, please take down. এটা একসঙ্গে 5টা অ্যাপিল দিতে 7টা অ্যাপিল আমি একটা ডিকটেশন দিচ্ছি আপনি এটা নিন কিছু কিছু জায়গায় যেগুলো আন্ডারলাইন করতে হলো আন্ডারলাইন করবেন ঠিক আছে আন্ডারলাইন করবেন দিয়ে ওটা সব ভালো now item number 22 and 23. The instant appeal is preferred against the judgment and award dated 20th December 2017. It underline করবেন 20th December 2017. Passed by the learned judge, Motor Accident Claim Tribunal, ADJ Fast Track Court, Coach Bihar, in MSC case number 75 of 2009. Case number to underline করবেন. Stop. The brief fact of the case is that one company, namely Messrs. Kalpataru Power Transmission Limited, within bracket Construction Department, under the West Bengal State Electricity Board, has been conducted some capital AP DRP within bracket reconductoring bracket close revised allotted by capital AC and CM Jalpaiguri within bracket D circle void necessary approvals within Dinhata subdivision. Full stop. The said Messrs. Kalpataru Power Transmission Limited hired a truck being numbered WB 631425 from Coach Bihar Truck Owners Association for carrying electric poles having 8 meters long from Setai to Dinhata on condition that the said poles will be loaded and unloaded by their own laborers. According to such condition, the said poles were carrying by the said truck with 8 laborers for loading and unloading the said poles from Setai to Dinhata. Full stop. On 3/7/2006, when the said truck loaded with electric poles and 8 levers reached at village Bara Kaimari, Kaimari, under Sitol Kuchi PS at about 9 to 10:25 p.m. At the time, another vehicle which was coming from opposite direction. Then the said truck was given opportunity to cross the said vehicle with high speed and rash and negligent manner. And as a result, the driver of the alleged truck lost his control over the vehicle and the said truck was capsized in the side of the road. Stop. All on a sudden, 3 laborers out of 8 were jumped in another side, but rest 5 laborers, including the victim, along with said ECC poles, were fallen down in the other side, and the said 5 laborers were sustained severe multiple injury all over their persons by pressure of the said electric poles and died on the spot instantly. Stop. The next part, the legal heirs of the one of the labor, legal heirs of one of the labor, that the present victim filed an application before the learned tribunal under section 163A, capital A of MVR, for getting compensation. The claim case was contested by the insurance company as well as the owner of the offending vehicle by filing written statement. The learned tribunal, after hearing the parties and after receiving the evidence, has awarded a sum of rupees 4,49,500. It underlines 4 lakh. And directed the insurance company to pay the compensation. Stop. Being agreed by and dissatisfied with the said award, the insurance company has preferred the instant appeals. Stop. Next para. The claimants also preferred a cross appeal against the said award or enhancement of the award. Stop. Next para. Learned advocate Mr. Rajesh Singh, appearing on behalf of the insurance company, submits that the award passed by the learned tribunal is erroneous in law and the insurance company is not liable to pay the compensation. In support of his contention, he submits that the insurance policy, which was marked as Exhibit 3 before the learned tribunal, Exhibit 3 before the learned tribunal, Exhibit 3 to mark tribunal, shows that the policy in respect of the vehicle is liability, is marked as liability only. Liability only. Liability only. Liability only. Stop. Mr. Singh submits that according to the provisions of Section 147 of Motor Vehicles Act, the limits of liability of the insurance company to indemnify the owner is limited in the Act itself. Stop. The liability policy within the liability policy means the statutory liability of the insurance company to indemnify the owner. Stop. He referred the section 147 subsection B within bracket Roman small 1 I. He submits that the policy, the statutory policy covered against any liability which may incur by him in respect of death or bodily injury to any person, including the owner of the goods or his authorized representative carried in the motor vehicle. Stop. Admittedly, the offending vehicle is a truck and it's a goods vehicle. In respect of the goods vehicle, the owner and the owner of the good and the authorized representative carried in the said motor vehicle are covered. Stop. The present victim is the labor of Messrs. Kalpataru Power Transmission Limited. So they are not actually covered under the policy of the insurance company. He submits that the learned tribunal has committed error and directed the insurance company to pay the compensation. In this case, the error directing the insurance company to pay the compensation. In this case, full stop. In this case, the owner has violated the terms of the policy So the owner, so the insurance company, so the owner of the offending vehicle may be directed to pay the compensation. In support of his contention, he cited a decision of Honorable Appellate Court passed in Sanjeev Kumar Samrat versus National Insurance Company Limited. Stop. Nice. Paragraph 24. Paragraph 24. Set out code. Stop. Mr. Singh further submits that the insurance company has deposited the entire awarded sum with the office of the learned Registration High Court, Calcutta. So necessary direction stop. However, Mr. may be made. Next paragraph. However, Mr. Singh further admits that by virtue of decision of Honorable Apex Court in Urmila Haldar, the fixed compensation of this case would be 5 lakh. 5 lakh. Which Learned Advocate Mr. Rama, appearing on behalf of the insurance company and appearing on behalf of the claimant, submits that the Learned Tribunal has not committed any error by directing the insurance company to pay the compensation. He submits that the fact goes to show that the present victim is the labor who was engaged by the Mrs. Kalpataru Power Transmission Limited to load and unload the truck, unload the electric poles at the truck. He submits that they are the representative of the owner, of the goods. So they are actually they are entitled to get the compensation. Stop. Or the Learned Advocate. Where is the materials on record? It appears that the present victim is one of the labor who died due to the fatal accident by capsizing of the truck carrying the electric poles. Truck. The fact goes to show that the truck was hired by Mrs. Kalpataru Power Transmission Limited from the owner to carry the poles. Stop. It is true that the necessity of the labors to load and unload of the electric poles is required, but they cannot be termed as a employer of the owner of the electric poles. Considering the situation, the present victim and the laborers, being the laborers, can be termed as a gratuitous passenger. Termed as a gratuitous passenger. Gratuitous passenger. In Sanjeev Kumar Samrat, the Honorable Apex Court has held that though the insurance company may not liable to pay the compensation in terms of section 147 within bracket 1 within bracket small b within bracket capital within bracket Roman small 1 of MV Act, but the Honorable Apex Court has held that as the according to the observation of Honorable Apex Court in National Insurance Company Limited versus Baljit Kaur and others. The insurance company may be directed to pay the compensation, and thereafter they are at liberty to recover the same from the owner of the offending vehicle. Stop. In this case, it appears to me that the same principle may be applicable. However, in considering the observation of Honorable Supreme Court in Urmila Haldar, the fixed compensation of this case would be 5 lakh. Stop. It appears that the insurance company has deposited the entire awarded sum of rupees 4,49,500 along with the statutory deposit of rupees 25,000. Stop. The said amount must have carried some interest. Stop. The in this case, only 25,500 has to be deposited by the insurance company. Stop. No. Keep on number. Interest. No, in this case, the insurance company, the Office of the Land Registration, High Court, Calcutta, is directed to disburse the amount in the name of the claimants according to the direction of the Land Tribunal within 4 weeks. Stop. The rest amount of rupees 25,500.
449,500 and 25,000, your lordship has taken note of that.
Yes.
So, my lord, the balance is now
25,500.
25,500. But with 25,500, কি করবো ডাইরেক্ট পাঠিয়ে দিই আদারওয়াইজ তুমি আবার পয়সা তুলবে খবর দিবে আবার
তোমাকে ব্যাংক অ্যাকাউন্ট
তাহলে 25,000 your lordship will simplify things. Maybe they would get a little less, but your lordship will only record this that the 25,500 with accrued interest from the date of filing of claim application would be sent directly to
But they have to furnish the same.
to the claimants within 4 weeks from furnishing of the bank particulars to the insurance company.
Okay.
In the proportion as decided by it.
মেবি
ঠিক আছে আর এখান থেকে পুরো মিনিট they will take the entire money.
Yes.
Will not get into the further calculation.
25,500 along with 6% interest per annum from the date of filing of the claim application has to be paid by the insurance company directly to the claimants at their bank account to be furnished by them to the office of the insurance company within 6 weeks.
From the date of receiving of the
Within 6 weeks from the date of receiving the information along with the bank particulars to their bank account directly according to the proportion fixed by the law and tribunal.
my lord is giving us the right to recover.
Yes. Next paragraph. The insurance company is directed, is at liberty. No, after such payment, the insurance company, after such payment, the insurance company is at liberty to recover the entire awarded sum from the owner of the offending vehicle, according to the law laid down by the owner of the court in Baljika. Supra. Stop. Affirmative connected applications, including the court. Amount দেখে নেবেন 119 of 2018 disposed of. Now, what about the the payment of compensation is subject to ascertainment of payment of deficit court fee. Stop. The Planetary Tribunal shall act upon the certified copy of this order to receive the deficit court fee. Shall not order. সবুজ এটা করো আর এটা আমি বার করো কি করবে এটা বলতে নামগুলো শুধু চেঞ্জ হবে আর বলেছেন বললে ওকে
Milord, with regard to the other three matters, Milord, I'll indicate your lordship, not the amount, because the finding of my lord would remain same. Only the name would change.
all name and amount would be changed.
Name and the amount would change. Milord, shall we be indicating your lordship to the amount or lordship?
No, not necessary. I'll take
Lordship will kindly, because Milord, in all the cases, Milord, 25,000 extra, and Milord, the balance.
in all the cases.
In all the cases. In all the cases. In case of any confusion, Milord, lordship will kindly keep it for the next.
Yes,
day,
yes.
Milord, to clarify. And Milord, I must also indicate. Milord, I must indicate to your lordship, Milord, I've just received information, Mr. Kapoor, Milord, Mr. S.K. Kapoor, but he has expired.
Is it?
Yes, Milord. Milord, perhaps the best what we had, Milord, because when I worked with him, Milord, the most, Milord, versatile advocate was equally good, Milord, in civil as well as criminal, in company as well as constitution. I haven't seen, Milord, any other gentleman advocate, Milord, who is equally proficient in all these fields, Milord. He was perhaps the best what we had. Just number the information came that, Milord, he has expired, and perhaps the resolution is not
father of our
power of justice, Milord,
Yes,
Ravi Krishnan, Milord. Yes. But to me, Milord, he was perhaps one of the best what we had here. Because we had, Milord, different barristers or advocates who were, Milord, very good in one particular field. But Mr. Kapoor, Milord, he was absolutely versatile. Milord, maybe, Milord, we would not be having court, Milord, but the resolution is not here. But Milord, the talks are on that the meeting would be held after 2 o'clock. And maybe on Monday also, Milord.
Yes,
Milord,
yes.
will not be. Just for my lord's information.
Okay.
Yes, we do.
And other matters will be dictated in the chamber or not in the court.
All would be the same. Only
But
the amount would be changed.
then, but I've got two can Milord in two other matters. Just to note the majority, I'm supplying the can.
Okay. All of the cans are there in the file.
The can
If they are on the file, I will dispose of them. No issue.
the can is
Jodi-
probably not
Jodi-
here. Can নেই
ট্রিবিউনাল বলেছে বাংলাদেশের পয়সা দিতে তাহলে তো ডাইরেক্ট চলে যাবে দিয়ে দেবে
না না এখান থেকে নেব তো মানে can is
If can is in the list and the file, then I will dispose of.
can is not in the list.
Then you have to prefer you have to mention it. Okay.
We are extremely obliged to man.
Yes. এই রিপোর্টটা দিন দাদা। এই দাদা নাম্বারটা ভুল আছে। সাপ্লিমেন্টারি
Which for the petitioner? Which for the petitioner?
petitioner not appearing on last occasion since
Petitioner is
Maybe.
not appearing.
not appearing.
So the finding is that report is not comprehensive.
Then after my lord, report comprehensive.
What is the
report,
matter?
Matter is under section Gangaram to PS case number such and such.
Now why the
Under
CR
section-
is preferred? CRR, why the CRR is preferred?
Here quashing
For quashing,
quashing of
for
the
quashing of
entire proceeding.
entire proceeding. What is the stage? Charge sheet submitted.
The charge sheet already trial completed, acquittal. All accused persons are acquitted. This judgment of this case was annexed in the report, my lord.
So what is the purpose? For filing the CRR?
CRR filed in 1917,
Infractuous.
2017.
Infractuous.
Then after my lord, trial completed. Then after trial completed.
The difficulty is I am not holding the chair, so that is the reason I am not a regular court. So what is the finding regarding the incomprehensive report?
Detailed report was with the-
Earlier some report was there.
there.
What is the
But only there is all the accused persons are acquitted. Not detail is mentioned in the report.
okay? So now this is the memo of evidence. No. You on the earlier memo of evidence, whether you have stated that the matter was disposed of or acquitted? No. Only charge sheet, after charge sheet the report was there.
Okay.
That is the view. Okay.
And subsequently report was that the accused person, petitioners including other accused persons are acquitted. But detailed report is not there. Now the judgment including detailed status report and the case status, everything is filed. Certified copy of the judgment is here with the report, latest report.
What is your name?
Shantanu Mitra.
Santanu Mitro. Please take down. You are the IC of Gangarampur PS. IC Santanu Mitro. Gangarampur Police Station, Dakhin Dinajpur. Is personally present. Stop. The IC submits the status report containing the certified copy of the judgment dated 4th day of July 2022, passed by the learned additional session judge, First Court, Balurghat, Dakhin Dinajpur, in special case number 17 of 2018, stroke sessions ST number, sessions trial number 17 of 2019. Stop. Appearance of IC Santanu Mitro, Gangarampur PS, is taken on record. The status report be kept in the record. Stop. Considering the status report and considering the facts and circumstances of this case, the personal appearance of the IC Santanu Mitro is dispensed with. Let the matter appear in the list on 16th of April.
In this bench. In that original.
In regular bench.
In regular.
Before the regular bench. Before the regular bench. Yes. কি করবে? একটা কল করো।
Perhaps there is a resolution, my lord,
Yes.
which we can't appear, my lord.
Very. Okay. These are the upgraded. Okay. Thanks.